It's Thursday. As usual, every Thursday we strive to have a justice conversation. Looking at accessing justice, we talk to people in the judiciary, or we talk to people who are in the justice sector. It could be prosecutors, it could be police officers, it could be civil society organizations or community-based organizations that are involved in a whole conversation on justice. Today, we're talking to somebody from the judiciary, specifically from the Environment and Land Court of the Judiciary, the Honorable Justice Oguttu Mboya. Good morning, Judge.
Good morning, everyone.
How are you?
I am very good, and how are you?
Very well.
Very well, thank you,
Thank you.
Judge, we're in February. Welcome to February.
And it's
We've
still
been here a
Happy
while.
New Year.
Yes,
it is.
In fact, this one is a happy one. It's 2025. January is gone with a year, with that other year. We are moving.
You are misleading.
It's 2025, City.
Bro, let us at least settle into 2024.
Do you remember when you had Christmas? Can you remember? It was such a long time ago. It was last year but one, my friend.
Sky is operating in a different stratosphere.
No, he's right.
Of course he is.
January was a whole 12 months by itself.
December is a blur. And in many cases, a painful blur.
Oh, yes.
You're wondering, where did the money go? So here we are in 2024.
Yeah. Have we made a solid argument, Judge?
How do you interpret this?
Umeonaje? We made a convincing case.
Yes.
That we are right in 2025.
Yes.
Because January, which is deemed to be the difficult month, is gone.
Yes.
January is difficult because you see it's a lie. It's not 1 month.
It's all 12 months in itself.
When they give you a discount, it's around 4 months.
Judge Karibu Sana, it's good to have you here.
Thank you so much.
We want to understand the Environment and Land Court. We know there's some new developments of what you've done internally in making sure that this court then delivers justice better, more efficiently, faster to people. You serve in the Land Court at Milimani. And you
I
tell us
serve in the land division.
in the land division of the Environment and Land
Court.
Court. That division is what we want to know. So this division, what does it mean? So, but Karibu for the conversation. City is going to give you the day's proverb.
Yes.
This week you're in?
The country of Zimbabwe.
Right.
Yes, a very interesting country, as I keep saying. The only country on this continent that at its independence, which was the UDI, had a white prime minister, meaning it had a head of state who was absolutely white, a gentleman by the name of Ian Smith. Yes. But that UDI was rescinded at some point, around 1979. That UDI was 1965. Then Rhodesia became Zimbabwe. Yeah, that was really 1980. An interesting country, this one. Very, very interesting. Now the proverb, a coward has no scar.
A coward has no scar. Justice Oguttu,
Yes.
what is your interpretation of this proverb?
My interpretation of that proverb connotes that, if you are a coward, then you don't have to confront any battle. And because you don't confront a battle, you don't accrue any scar. So you are blameless.
So is it a good thing or a bad thing?
Well, in my view, life is a journey. Being a journey, there are very many encounters that one must go through, some of them very bruising, some of them not very palatable. But you must allow me to say this, contend with all those situations. And in the course of it, at the tail end, you will accrue scars. So it is not a good thing to be a coward.
Not a good thing.
In my humble view.
It means that
so.
you're just floating through life.
Yes.
Okay.
Or running away from it.
Or running away from life.
And they say success doesn't belong to cowards.
Now, Judge, we've had conversations with several of your colleagues from the Environment and Land Court. We understand it's a superior court created by the Constitution, equal to the High Court, specifically dealing with environment and land matters. And we have talked about many times, what does it mean, environment and land matters? How many cases do you face in court and all? But it's been at least 10 years since this court was established. Let's go into which of those...
You perhaps need to add one more year on
11,
top
eh?
of it.
Yeah, 11 years. We are in the 11th year or in the 12th year?
We are getting into the 12th year.
Yeah. So, between environment and land matters, how many do you actually find yourself dealing with most? And is there a reason why?
Allow me to point out that yes, it is a superior court. 2, that it is a court with equal status with the High Court, but status does not mean that they have same jurisdiction. Their jurisdictions are different and delineated by the Constitution. The status is just in terms of the judges. They are all peon judges. They all accrue same terms, most probably same remuneration, but in terms of jurisdiction, the Environment and Land Court is established by dint of Article 162 2B. And it is specialized in nature, and it deals with environment and land matters. In this dichotomy, land matters, and as you very well and we very well know, are politically sensitive, culturally complex, and very emotive. They say very emotive. So in our country, because of the love for land, the land cases far outweigh those with environmental inclinations. So at the Milimani ELC, the number of land cases, those are disputes that pertain to title to use of or occupation of land in its diverse perspectives, are more than environmental matters.
Okay.
And perhaps I may also wish to add that environmental matters are complex in a way because they require scientific interrogation, which the ordinary persons perhaps are not able to gather, to get to. That's one. Then 2, many a times human beings look into issues as to what do I get out of it. So in land disputes, you see, you're fighting to protect your interests, mine.
Yeah.
But in environmental issues, they take a different dimension. So they really, yes, they do affect you and me at our personal levels, but then they have a wider perspective, and therefore many a person do not, just extremely very few. Remember Wangari Maathai, and how many Kenyans were with her. You notice she was one of the founding environmentalists, right?
Yeah.
And for a long time, perhaps the sole voice speaking for the environment. So it continues to subsist. The number of environmental matters that we have are not quite many. Indeed, allow me to point out that the establishment of the Environment and Planning Division was actually intended to foster a scenario where we could create awareness and cause Kenyans and many other persons to partake of this right provided for under Article 42. The right to clean and healthy environment. But still, the number of cases are not
as many.
Not as many.
Okay.
Perhaps in comparison should be 2 to 8.
Oh, wow.
2 environment to 8 land cases.
8 land cases.
Okay. No.
Okay. When we look at some of these cases and we just hear of the land cases that, whether individuals have brought their cases to court, the element of time comes into play. And I guess a very simple question is that time being a factor, why do they take such a long time to adjudicate?
Now, Allow me to start from a dimension that before Kenyans, you and me, ultimately voted for the current constitution, the Constitution 2010, land matters were lumped together, heaped together with all those other matters, criminal cases, civil cases of different dimensions. And given the three critical issues I alluded to, one, politically sensitive, culturally complex, very emotive. You notice they pit mother against son, son against father, husband brother against husband against wife. That denotes how emotive they are. But the point is that in the time when they were lumped together and they were being dealt with by the High Court, they were not being prioritized, perhaps informed by these three critical issues. And then two, the land law regime that was hitherto obtaining in Kenya was also a little complex, because we had assorted regimes governing land registration, land administration, land use, and the registries were also scattered across. We had the Registration of Titles Act, we had the Registered Land Act, we had the Government Land Act, we had the Trust Land Act, we had the Group Representatives Land Act, all of them with different dimension. And this created a bit of a difficulty. But then fast forward under the Constitution towards harmonization, we then now only currently have two operative land law regimes. There is the Land Registration Act and the Land Act. This has harmonized the process. This is towards fast-tracking the hearing and determination. This is towards making it easier for you and me, without legal knowledge and training, to be able to appreciate. And this difficulty also contributed. But then again, the other reason that belies the amount of time is also the amount of cases. They come in various perspectives, various dimensions.
For example?
You and me fighting over ownership of land. The other one, you taking an aspect, a criminal aspect, for forcible detainer or forcible retainer. You taking a criminal action for trespass. You and me, or me and her, fighting over matrimonial property. All these, and they are interlinked. And there is also the succession aspect. So all this, you would find a dispute is in the succession court, fighting over land. Someone has clothed it differently and walked the same dispute or near same dispute to the land court. It's just a question of a perspective. You twist it this way, twist it this way. So this creates a quagmire of sorts. So all this, and then you and me also are aware that the number of judges vis-a-vis the current population, because even at this juncture, the current Chief Justice has a blueprint called Social Transformation through Access to Justice, which is more people-centered, right? Which is geared towards effective service delivery. And one of the key pillars is an endeavor to render real-time justice, hear and dispose of these matters within 365 days from date of inception. But then looking at the number of judges vis-a-vis
the population and the cases,
it's not a reality, and this is the reason why we keep talking about more funding, more judges.
So the Environment and Land Court, if we're looking at now the lands aspect, do only sit in Nairobi? or is there avenues to have some of these cases sat in other parts of the country?
Perhaps one thing that you need to appreciate is the Environment and Land Court is not only sitting in Nairobi. We have judges sitting across, I think, 37 counties that have judges. Our endeavor is to ensure that each and every county has an ELC judge towards decentralizing, or is it devolving judicial services. So we are not only sitting in Nairobi. Currently we are 8 ELC judges sitting in Nairobi, but with effect from the 1st of March, we will be 7, because one of us has since been relocated to Voi, so that Voi, this should be Taita Taveta County, would now have a sitting ELC judge. So we sit across the country.
There are alternate mechanisms for attaining justice.
Yes.
And they've been spoken of at great length by some of your colleagues who have come here. Please walk us through how this can and or does work out in the court that you represent.
Yes, maybe allow me to start from the perspective that this alternative justice system is not only a creature of the Constitution, but is now a constitutional imperative.
Yes.
It is underpinned by Article 159 2C of the Constitution. Perhaps you and me, I say you and me because we both voted for the Constitution. This was a Constitution that we subjected to the referendum, and we voted, and we said this bit is good. We came to the realization that the old thinking that disputes can only be sorted out and handled by the judiciary was outdated. And this then brought to the fore the expansive thinking that brought on board the alternative justice system. It does work for my court, and I will, before I get there, allow me just to break them down. When we talk about the alternative justice system, these are those systems that are geared towards achieving and rendering justice to the people without necessity of approaching the court. There are a myriad of them. There could be one where we call reconciliation. You and me had a dispute, but we can sit, talk, and that is reconciliation. There is mediation, which would require the intervention of a third party sitting to help us patch up. Then there is conciliation, which is many a times used in the Employment and Labor Relations Court, which is the twin court to the Environment and Land Court, but deals with employment and related issues. Then there is also the court-annexed mediation. And then we have the traditional dispute resolution mechanisms. So long as there's a caveat, the mechanisms are not repugnant to the Constitution and the constitutional principles. For my court, taking into account the diverse and complex and sensitive nature of issues that do arise, alternative justice system would suffice. And I did mention land disputes because land is stagnant, but the population is growing. So each and every one of us is yearning for peace. We've gotten to a scenario where you find mother against son, or son against mother, father against daughter. All this. So these are disputes that concern land, but having a domestic perspective. In this kind of scenario, taking into account the necessity to foster relationship in this family, an alternative justice system would work better and be efficacious than our adversarial system. Ours is you and me are adversaries. The judge moderates. And there is no draw, 0-0, 1-1. No, there must be a win, which must be proclaimed. You like it or not, but you see, that is the nature of our system. But the alternative justice system has a window, perhaps a door, for a win-win situation.
How effective is it in terms, because cases don't start in the courts, they end up in the courts. So a problem arises in some place over land. Like in the last year, one in Machakos, before you knew it, there's another one in the easterly parts of Nairobi, people. And that's just the tip of the iceberg. There is no part of this country where one doesn't hear of a problem with land. I wanted to understand these alternate resolution mechanisms that we have, how effective are they in places where, forget these large ones, those ones have to go to court, there's no question about it, I understand that, but the one where, as you say, it's a family issue, it's a neighbor issue, somebody has decided to encroach on my land, somebody has decided, how effective are these things handled and managed? And do we hear of good success rates when it comes to resolution of these problems?
Via the alternative justice system?
Yes.
Quite a number. It's a mechanism that Chief Justice Emeritus D.K. Maraga really fought for, and it culminated into what we call the court-annexed mediation. And this court-annexed mediation has trained mediators from all perspectives of lives, pastors, engineers, etc. And there are matters referred to them, and there's actually a registrar for mediation. So you refer a matter to the registrar mediation. The registrar mediation would constitute or appoint a mediator, refer the matter, and there is a return rate of 60 days for them to report back. And I want to report that it has really been helpful in trying to reduce the backlog that was hitherto there. Well, still there, but not at that level where it was, because we call this an innovative mechanism. So we must think outside the box. But it has been effective.
Great.
But I'm not saying 100%.
You'll tell us the percentage. And Judge, like you've said, you receive very many cases, varied in the way they're presented. Very many of them, some of them starting from family disputes to commercial land disputes to even people complaining about government. From what you see, is there a clear understanding of land rights in the country by the people? Is there a clear understanding of land ownership processes and rights by the people?
Yes, I would confirm that the enactment or the promulgation of the current constitution really crystallized the land rights, both in terms of private land ownership, public land, and community lands. And these distinctions are well drawn by the Constitution. And secondly, I would point out that yes, a better percentage of Kenyans now do appreciate and understand their rights and entitlement to land. And this understanding of the scope of their rights has actually culminated into a number of suits, because hitherto some of them were like their land rights were being trampled on, yet they did not know. But there is enhanced knowledge, there is enhanced information, and quite a number of Kenyans are now litigating to defend their land rights.
Is there understanding of the process of ownership of land? Because in the many cases that we see, in fact, when you're seeing demolitions whose orders whose process has been sanctioned by court, many people come and say, you know what, I've lived here for all these years. I bought this land from a third party who bought from somebody else. And as far as I'm concerned, I own this piece of land. In fact, government has allowed me to do this and the other. In fact, I checked, in fact, this and that. Is there really understanding of what it means when you say this is my piece of land?
Allow me to point out this. Yes, I agree that we've gotten into situations where people who have previously been in occupation of certain parcels of land for vast number of years on the basis of some certificates of title which they imagined were valid, face or are confronted with eviction, demolition, like the ones that you and me have witnessed, not in the very distant past.
Yeah.
But we adopted a registration system which is called the Torrens principle. It's borrowed from an Australian Prime Minister, and this is a system that was gotten from Australia, which, if it is effectively deployed and utilized, would ensure that the moment you walk out of a land registry, irrespective of the county or which land registry you came from with that title, that title would be worth the weight,
paper it's printed on,
the ink, and whatever that is written thereon. But fast forward, something happened. Because one of the key pillars of this Torrens principle that we borrowed, where the registration document should speak to your indefeasible, to your absolute right, and confirm yes, and with indemnity from the government, has not been effectively utilized. And this is where we get a scenario where there are 2, 3, or even more sets of titles relating to the same piece of land. And sometimes we just fiddle with the numbering. Nairobi block, then 10. But I create another one, Nairobi block 1/10. But the land doesn't move. It's the same ground. So you get titles superimposed on titles. But it is the same land. 3 people laying a claim to it. It's because the fidelity to the principle underpinned by the Torrens principle has been thrown to the dogs.
By who?
By us, you and me, Kenyans. Because I would not want to say that it belongs there. It's a collective thing. Because it is me who knows this land belongs to you. But despite that, I still go there and I say yes. That title.
So are we saying, so are we saying then in that aspect?
But principally, the people that owe us a duty who sit at those prestigious offices, who will, land alienation or land allocation or land registration is not an event. It's indeed a process which would start by a physical planner doing a document called a part development plan, which will speak to the existence of that plot or that portion of land that is desired to be. Then we move to the Directorate of Survey, would then do a deed plan, which would speak to the delineations, the boundaries of the land, of course authenticating, yes. Then we walk up to the registration. But somewhere the process is not watertight. And this is how you find that there are parallel titles, there are parallel registers obtaining at the land registry. And allow me just to add this. Because of this complex scenario that lies on the path to registration, which will then come to the Environment and Land Court, we, under the leadership of Lady Justice Mboya, who is now the head of the land division at Milimani, sat and thought through the process. And we were looking at a scenario that would we be able to resolve all these disputes without engaging with all the stakeholders, because there is a segment of this dispute that is created by the Directorate of Physical Planning. There is a segment that is created by the Directorate of Survey. And you and me also know that the county government also had land that was belonging to it, and which was being alienated by the Office of the Commission of Land, as it then were, under the Government Land Act. But that could only be done with the approval and sanction of the National City Council or TC. But they also had their own issues, because you have your flatterers and you want to reward them. So you reward him with that land. Tomorrow you get out of office, and we have scenarios of one piece of land being allocated double and double and double, right? So we created a scenario that we need to have a talk to be able to see that we can avert or mitigate the number of cases if these offices were to pay fidelity to the statutes that underpin their existence. Because the biggest problem we do have, and allow me to underscore this, Kenya and Kenyans have sufficient legislation, both starting from the Constitution, the statutes, and the regulations. What is missing is perhaps the spirit to actualize the text of the law and the attitude.
So then, isn't that where a problem comes in? And I want to look at 12 years of this specific court being in existence, but also 14 years of the Constitution. And when the discussions around the Constitution were taking place, land was central. Land occupied a huge part of the conversations. There was even creation of the National Land Commission and dedication to conversations on land, and we are still finding ourselves with a system that is yet to be aligned at system level, not even at a community level. Should we have a national land conference that then brings in together all the players and says, this is what the people of Kenya decided and put in their constitution. This is what has been enacted as laws and regulations, but these are the gaps in implementation of these laws, and we must find a solution to it. As you say, to come together and say, we are the problem, we must discuss so that we can resolve this problem, because we are hurtling towards a very bad corner.
Let me take it from a three-pronged approach. As to whether we need a national land conference to enable us to speak to the land issue, my answer would be in the negative. in terms of text, in terms of law, starting, as you correctly pointed out, during the clamor for the constitutional change, land and governance are two critical issues that took center stage. Remember, we were kind of seeking to run away from a dictatorial governance. And this culminated into the enactment of what we call the national values and principles of governance, which are very expansive and they speak very well. But then the question as to whether there is compliance is another discourse for another day. Fast forward to the land issue. Starting from Article 60, which defines the national land principles that Kenya espouses. And it goes down to 61 that defines the types of land from private, public, community. And then it goes down to 62 that defines about rights, and it goes down about how your land rights can be utilized. Of particular importance is Article 60 of the Constitution, and some of the very fundamental principles that are entrenched there is equitable access. Access to you, to me, to everyone, irrespective of political, socio-economic status. Sound land management and administration, right? Protection of land, land right security, you know, that when you have a certificate of title gotten from speaking to your land right, those land rights denoted by that title should offer you some
level of security,
as to whether that has been achieved. Well, is also debatable because these are part of the issues. But I would say we have a beautiful constitution that is very comprehensive and espouses all the principles that we would need.
So what do we need then? So you say we don't need a conference, a conversation.
Yes.
But we have a problem, and that problem is ending up in your court.
We actually need,
with people being buried.
In one word, an enforcement mechanism.
Like what? The National Land Police.
Can I ask a question this way? That if you saw that some of the things you not even allude to said very clearly, if there was elimination of the mismanagement of the process at these institutions and agencies, which would then guarantee that there was a free flow of information and that there was the proper reception of the documentation needed on either party's side, would we see a reduction of these cases in your court? Number one. Number two, are we also saying then that if there was due diligence done on the part of both sides of those on this transaction, we would also see a reduction of the cases then that came to the lands court? Would we?
A yes and no. A yes and no because of this. Let me start with the due diligence being done by both parties to the transaction. This would then mean the seller and the other one is the purchaser. I mentioned and I alluded to a scenario, a very pathetic one, where it's not only double title, that one you have in your house and you're keeping in your safe, and the other one that I have and I'm keeping in my bedroom, beneath the bed, right? There is also a parallel existence of parcel files at certain offices. So that when you are speaking about doing or undertaking due diligence, if that pathetic situation does remain and exists, and there are two parcels, you want to do due diligence and depending on the
office you land.
understudy and a few preliminary questions, perhaps they'll ask you, why do you want the search? And I want to buy the land. Oh, who is selling to you? And you will think it's a very innocent question, but then someone somewhere has, and then say, oh, okay, then your due diligence would then drive the person to parcel file B, which would give you the info that speaks to the due diligence that you are looking for. But there is a parcel file A concerning the same land, which has a different. So really, due diligence, yes, but how effective, how efficacious, it's debatable, because the very principle that underpinned our registration system has been botched. It was, for those in Australia, for those in the UK, a title deed certainly means that you have land rights.
And it's clear.
And it is. You can walk with it. But you see ours, the scenarios that we have, like just the other day, all of us live in this country, there was massive demolition on land which was said to belong to Mombasa Cement or Portland Cement. And it was massive. And there are Kenyans who say, look, we bought land and we got title. So if they got title, where did they get it from? From some government office. Where then is the land, the security of the land tenure system? How effective, how helpful will due diligence be? Because today we actually, right now, we are not talking about superficial due diligence. There is yet another concept that has come forth, which is very critical. That is not enough to do due diligence. You must undertake historical interrogation and investigation of the land to know, oh, how did you come, and how
did you get to own this land?
You see, some kind, and then you see this then takes you away from just the land registration section and dispatches you to the Directorate of Survey to discern whether the survey maps that underpin this. So they say due diligence, yes, superficially on the face of the water, but beneath the water they are running tight. So you must do historical search.
It's a lot.
And then the other bit that is also there is the Independent Constitutional Commission.
That's a whole kettle of fish, Judge. I'm going to catch you there.
Like a National Land Commission, you say, would the number of cases that come to the ELC be mitigated if this was functional? But I would share with you that
Sorry, I've got to cut you short there. We've come to the end of the hour. An interesting conversation. Please, let's continue with it soon. The Honorable Justice Oguttu Mboya is the judge from the Environment and Land Court in the Land and Planning Division at Milimani. We've been talking about justice and land matters in the country.